Hi, so today we'll be learning Preamble and Article 12 of the Constitution of India. Preamble is the opening document of the Constitution of India. It is one page in which the power from which Constitution derives its existence is written. What is that power? We the people of India. We the people of India is the power from which the Constitution derives its existence. This should always be kept in mind by all of us. So, we the people of India have come forward and given us this Constitution and the Preamble. The Preamble says, we the people of India, along with several words like sovereign, republic, secular, socialist, democratic, republic. And then it goes on to give us justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and opportunity, and to promote among us fraternity, assuring the dignity of the individual and the unity and integrity of the nation. That is what the preamble gives us. The words secular and socialist were added in the preamble by the 42nd Amendment Act. 42nd Amendment Act is called the mini constitution because a lot of things were added in the constitution by the way of amendment during the time of Indira Gandhi. So now you will say that since preamble is the opening document, then it should is it part of the constitution, or is it just a opening document like a preface to a book? So this question was answered in Inri Berubari. Inri Berubari, they said that preamble is not part of the constitution. It is just a opening document to the constitution. But the law of the land now exists according to Keshwanand Bharti case is that preamble is part of the constitution and it can be amended, but the basic features enshrined in it should not be destroyed. We learned about the basic structure in the past video. So the basic features should not be tampered or amended, but the preamble is part of the constitution. As of today, in 2026, the law states that preamble is part of the constitution and can be amended except for the basic features enshrined in it, like a democratic form of government and liberty of the individual. So all of these things, they should not be amended, but the preamble can be amended. So this is about the preamble. Now we'll move to Article 12. Now we have come to the territory of Part 3 of the Constitution, which contains fundamental rights of individuals. So in Article 12, they enshrine the concept of the state. यहाँ पे स्टेट का मतलब राज्य नहीं है. स्टेट का मतलब राज्य नहीं है. जो राज्य होते हैं हमारे भारत, इंडिया जो भारत है कि राज्य जो होते हैं वो नहीं है. स्टेट का मतलब यहाँ पे है जिससे आप ये जो फंडामेंटल राइट्स हैं वो क्लेम कर सकते हो. आप किसी प्राइवेट पर्सन से क्लेम करना थोड़ा मुश्किल होगा. उसके लिए आपको स्पेसिफिकली दिखाना पड़ेगा कि वो स्टेट है, वो पार्ट ऑफ स्टेट है, तभी आप फंडामेंटल राइट्स क्लेम कर सकते हो स्टेट कोर्ट में, सुप्रीम कोर्ट में आर्टिकल 32 के अंडर और आर्टिकल 226 के अंडर हाई कोर्ट में. तो आपको ये दिखाना पड़ेगा कि जिसके भी अगेंस्ट आप क्लेम करना चाह रहे हो फंडामेंटल राइट्स, वो स्टेट के अंडर आता है कि नहीं. तो हम आर्टिकल 12 पे आएंगे जो कहता है कि स्टेट क्या है. नाउ स्टेट उसमें ऐसे डिफाइंड है कि द स्टेट इज़ द गवर्नमेंट and the Parliament of India. Government and Parliament of India at the central level. Then the government and legislatures of the state. Then all or other authorities within the territory of India. All or other authorities within the control of the government of India. All right. So जो गवर्नमेंट है इंडिया की, एग्जीक्यूटिव जिसे हम कहते हैं, वो इसके अंडर आता है. पार्लियामेंट इसके अंडर आती है, राज्यसभा और लोकसभा. लेजिस्लेचर जो भी स्टेट्स के हैं, स्टेट असेंबलीज जो होती हैं, वो स्टेट के अंडर आता है. गवर्नमेंट ऑफ एवरी स्टेट जो एग्जीक्यूटिव होती है, वो इसके अंडर आता है. और जो भी ऑल लोकल और अदर अथॉरिटीज़ जो विद इन द टेरिटरी ऑफ इंडिया हैं, वो इसके अंदर आती हैं. और ऑल और अदर अथॉरिटीज़ जो गवर्नमेंट ऑफ इंडिया के कंट्रोल में हैं, वो इसके अंदर आती हैं. अब आप कैसे, पहले जो दो पार्ट हैं वो तो क्लियर हैं कि गवर्नमेंट एंड पार्लियामेंट ऑफ इंडिया और गवर्नमेंट एंड लेजिस्लेचर ऑफ द स्टेट्स, ये तो क्लियर है कि क्या है. ऑल लोकल अथॉरिटीज़ जो हैं वो क्या हैं, लोकल अथॉरिटीज़ क्या होती हैं, और डेफिनेशन क्लॉज कॉन्स्टिट्यूशन का क्या है, कैसे इनको डिफ़ाइन करेंगे. लोकल अथॉरिटी क्या होती है और अदर अथॉरिटीज़ क्या होती हैं, इनको आप कैसे डिफ़ाइन करोगे. कॉन्स्टिट्यूशन का डेफिनेशन क्लॉज आपको पता है कहाँ है. कॉन्स्टिट्यूशन का डेफिनेशन क्लॉज आर्टिकल 366 में है. और आर्टिकल 367 कहता है कि कॉन्स्टिट्यूशन में जो भी कुछ डिफ़ाइन नहीं किया गया है उसको आपको जनरल क्लॉजेस एक्ट से लेना है. जनरल क्लॉजेस एक्ट में जो भी डेफिनेशंस दी गई हैं, अगर कॉन्स्टिट्यूशन में डिफ़ाइन नहीं है तो आर्टिकल 367 के अनुसार आपको जनरल क्लॉजेस एक्ट से वो डेफिनेशंस लेनी है. तो जनरल क्लॉजेस एक्ट में लोकल अथॉरिटीज़ डिफ़ाइंड है. लोकल अथॉरिटीज़ के लिए वो कहते हैं कि ऑल म्यूनिसपैलिटीज़, डिस्ट्रिक्ट बोर्ड, पंचायत, इम्प्रूवमेंट ट्रस्ट, माइनिंग सेटलमेंट बोर्ड, ये सब म्यूनिसपैलिटीज़, पंचायत, डिस्ट्रिक्ट बोर्ड्स, ये सब जो होते हैं वो लोकल अथॉरिटीज़ में आते हैं. तो लोकल अथॉरिटीज़ तो डिफ़ाइन हो गया. उसके बाद बचा अदर अथॉरिटीज़ विद इन द कंट्रोल ऑफ गवर्नमेंट ऑफ इंडिया. अदर अथॉरिटीज़ कहीं पे भी डिफ़ाइन नहीं है, ना वो कॉन्स्टिट्यूशन में डिफ़ाइंड है, ना वो जनरल क्लॉजेस एक्ट में डिफ़ाइंड है. तो हमें अदर अथॉरिटीज़ के लिए देखना पड़ेगा, क्योंकि बहुत सारी ऐसी अथॉरिटीज़ हैं जो गवर्नमेंट ऑफ इंडिया के कंट्रोल में आती हैं, पर क्या वो सभी अदर अथॉरिटीज़ में आ सकती हैं, उनके अगेंस्ट हम फंडामेंटल राइट्स क्लेम कर सकते हैं. तो ये देखना है. तो अदर अथॉरिटीज़ के लिए बहुत सारे केसेस हैं. केसेस में इंटरप्रेट किया गया है कि अदर अथॉरिटीज़ क्या होती हैं. अदर अथॉरिटीज़ में सबसे पहला जो केस आता है वो है यूनिवर्सिटी ऑफ मद्रास वर्सेस शांताबाई का. तो यूनिवर्सिटी ऑफ मद्रास वर्सेस शांताबाई में ये कहा गया था कि any authority exercising governmental or sovereign function should be considered other authority, and any person who is natural or juristic, like a natural person or a company or like a university, cannot be considered to be any other authority or state under Article 12. So they gave a very restrictive interpretation in University of Madras versus Shantabai. It was a Madras High Court judgment and it had persuasive value for other high courts. Then in Ujjambai versus State of UP, the restrictive interpretation was rejected. And then in the next case of Electricity Board of Rajasthan versus Mohan Lal, they said that other authorities are all the authorities that were created by the constitution or any statute. Statute is called law. So any law that was made, if any authority is made under some law, then it will be within the part of other authorities. All right. Then in Sukhdev versus Bhagat Ram, it was conclusively held that public sector enterprises like ONGC are authorities within Article 12. And in the case of Sukhdev versus Bhagat Ram, Justice Matthew specifically wrote a separate judgment and concurred with the majority that if functions of the corporations were of public importance and closely related to the government function, it should be treated as agency or instrumentality of the state. Right? So if the keywords are, if the corporation's functions are of public importance and closely related to government function, it should be treated as agency or instrumentality of the state. Right? That was given by Justice Matthew in Sukhdev versus Bhagat Ram regarding Article 12, other authorities. Then in R.D. Shetty versus Airport Authority of India, it was clearly discussed and there was 3 or 4 criteria determined to determine whether it is a other authority under Article 12. So they gave 3 and 4 criteria for determining whether other authority is included within state in Article 12. They said that if the financial resources of the state is the chief funder of the organization, then it will be other authority. If there is existence of deep and pervasive control of the state in that organization, deep and pervasive control, then it will be considered state. If their functional character is of government in essence, then it will be considered other authorities. And if a department of government is transferred to a corporation, then it will be considered other authority. Whether the corporation enjoys monopoly status, which is state conferred or state protected, then it will be considered other authority under Article 12. But all of this criteria is also illustrative and not conclusive. The court can decide based on the facts of the case whether the authority is other authority under Article 12. In my research grant in the Supreme Court, I have worked from 2014 to 2015 in the Supreme Court as a research assistant. So there was a case by BCCI in which it is a society, but in my case it was held that BCCI, despite being a society, has public importance functions and therefore included within the definition of state. So even a society can be, public sector enterprises though obviously can be, and universities and all of these who meet this criteria can be considered state under Article 12. So, and in that the last question comes whether judiciary is part of Article 12 or not, whether we can bring judiciary or judges imparting justice into court that you are taking away my fundamental rights. So in A.R. Antule versus R.S. Nayak, it was held that judges cannot derogate fundamental rights of others, but judiciary is not part of Article 12 state. So the administrative portion can be to a certain extent be part of the state in the judicial system, but judges are not part of Article 12 as per A.R. Antule versus R.S. Nayak case. So in this video we understood what is the preamble. Is preamble part of the Constitution? And what does the preamble say? Then we move to Article 12, the definition of state. What is state? The first two parts are clear. The third part is about local authorities, which can be ascertained from the General Clauses Act. And the fourth part is about other authorities within the control of Government of India. And for the interpretation of other authorities, we learned several cases, that how the criteria about institutes of public importance, or about the agency or instrumentality of the state criteria in R.D. Shetty case. And then we move to whether judiciary is part of the constitution of the state in the Constitution of India, against which fundamental rights can be claimed. So we understood that judges are not part of the state in Article 12 of the Constitution of India, but judiciary or the judicial system cannot abrogate fundamental rights of citizens. So in this video we covered Preamble and Article 12 of the Constitution. We'll meet again for the further development in fundamental rights. Till then, keep watching and keep learning.